Thank you so much for having me, everybody. First thing I want to say is I prepared nothing for today. Hope that's not disappointing. The reason I prepared nothing is because I figured this is probably not your first rodeo. So I thought I'd switch things around and ask you a couple of questions to begin with. First of all, by a raise of hands, how many of you know what estate planning is? Yeah, I wasn't sure. That's about half, okay? How many of you know what elder law is? Okay, about 2 of you. Okay, so very, very few people to this day even know what elder law is. Let me ask another question. How many of you have set up a living trust? Okay, so about 2/3 of you. And let me ask you this question. How many of you that set up a living trust did it more than 10 years ago and haven't looked at it at all? A few. Okay, let's say in the last 5 years, 5 years or more. Did you set it up? And you haven't looked at it? Okay. Okay, and how many of you, let's say in the last few years, you set up your living trust? Okay. 2007, that'd be about 8 years ago. Time flies, you don't really realize it. It's going by and you have a trust and you think everything is fine. And the point that I want to make about estate planning and the timing is not to be complacent, both with estate planning and what I'm about to talk about, which is elder law. But I'll just go off on a tangent of estate planning here for a second. A lot of you who set up your living trust and did your estate planning prior to 2010, there were completely different tax laws in effect. And we didn't know what the estate tax exemption would be. Back in the 90s when I first started doing this, it was $600,000. Then we had this crazy era from 2001 and 2010 where it went up to $1 million, gradually got up to $3.5 million. Then in 2010 it disappeared, and then they brought it back, $3.5 million back up to $5 million. Now it's currently $5,430,000 per person. Now, what is the estate tax? For those of you who don't know, it's very counterintuitive. In America, we have 27 forms of tax. The estate tax is completely the opposite of an income tax. When people think about taxes, they then usually think, oh, I received money, I have to pay tax on it. The estate tax system is the opposite. It says if you give away money, you have to pay tax on it. However, as the law stands today, you can give away $5,430,000 tax-free per person, or close to $11 million for a married couple, and you don't have to pay tax on it. What that means is that 99% of society is not going to have to worry about an estate tax. Okay? If you're lucky enough to have more than that, then you might have to pay 40 cents on the dollar to give away assets to your beneficiaries. But that's where we estate planning tax attorneys come in and we help to reduce that amount. Okay? But if you had a trust set up prior to 2010, I don't want you to be complacent. You probably need to go check it out because a lot of the trusts prior to that time were set up as trusts that split into sub-trusts for married couples. And the reason why is because we wanted to preserve an exemption for both the husband and the wife. So if there was only $1 million and the estate was going to be $1.5 million, when we knew that we had husband and wife had $1 million, husband had $1 million, we could preclude 100% of the taxes. But if we just left everything to a surviving spouse, at the death of the first spouse, there was no tax then. But then when you gave it away, the surviving spouse gave it away, they were looking at really a 50 cents on the dollar tax. So that's why back then we had all these trusts split into AB trusts, even ABC trusts, so that they could shelter the amount for both spouses and each one could get their exemption. Okay? However, the law changed in 2012. Now we have this exemption, first of all, that is $5,430,000 and climbing. And we also have a little check the box on our 706 estate tax return that allows one spouse to utilize the exemption of the other spouse. So even if you don't have, you have an estate that's above that $5,430,000, you still don't need a trust that splits into different trusts. Now, why is this so important? The reason that it's important is because after the death of the first spouse, the surviving spouse has a lot of administration, paperwork, and accounting to do in the thousands and thousands of dollars every year. They have to split apart all the assets and physically put half of the assets in one trust and half of the assets in the other trust. The trust that's there for the deceased spouse will ultimately go down to the beneficiaries, but it's there for the surviving spouse, but that has to be in an entity with a new tax ID number that's more similar to a corporation, okay? Versus the trust for the surviving spouse just remains as it is, like most people would think of it when they have a trust, it's just them, okay? So if you have a trust, that's not what we call a simple trust, a trust that splits apart, and your estate is not above that 5 million mark, or even 11 million, then you probably want to restate your trust into a simple trust, just so that the surviving spouse really doesn't have much to do, doesn't have to worry about tax returns every year, has very little administration to do, okay? So that's one point that I want to make about the estate planning aspect of living trusts or irrevocable trusts, if you have irrevocable trusts, okay? Now, what's the difference between estate planning and elder law? If I could sum it up in one question. Estate planning asks the question, what happens if I die? And elder law asks the question, what happens if I live? Okay, very, very different. 20 years ago, when I first started in this business, people weren't living as long, and the cost of care wasn't as expensive. Right, and it keeps the cost these days, it keeps going up, people keep living longer. A lot of times they're otherwise healthy, but dementia, Alzheimer's, a lot of these afflictions occur, which causes the cost of care to go higher and higher. So, if you haven't planned for this, then a lot of people are in for a big shock. What's more is that people have estate plans in place. They think, oh, I have a trust, I have a power of attorney, I'm fine. But actually, a lot of the times, those living trusts and powers of attorney that you created for estate planning purposes are very counterproductive for elder law purposes. And here's the reason why. And when you have a trust, you say, I hold everything in trust for my benefit, which makes sense. Or maybe mine and my spouse's benefit. Okay? When you do a power of attorney, an estate planning power of attorney, you're saying, okay, I want to do everything myself, but if I become incapacitated, I want my agent to have the ability to do things for my benefit. Again, always for my benefit. And again, that makes sense. That's usually what you want to do. But when you're talking about elder law and qualifying for government benefits, you want to have an ability to do something that's very counterintuitive. You want to have the ability to divest, the agent to divest you of assets. Let's say it's a spouse. You want the spouse to be able to take assets away from you and put it into their name, or perhaps an agent to do the same thing. And the reason why is because, simply put, the costs of care. It's so expensive. There's only 4 ways that you can pay for your care. It's either coming out of your own pocket, you were fortunate enough and smart enough and had the money to buy long-term care insurance, okay, which most people didn't. You're a veteran who served during a time of war, and you have the ability to get veterans aid and attendance benefits. By the way, do we have any veterans in the room?
Why?
Yeah, okay. Surviving spouses can get, this year, up to $1,149 a month in aid and attendance pension benefits to help pay for care. A lot of people don't know that. And the 4th way is through Medi-Cal. I have clients, they go into the hospital, they go into skilled care. I have one right now. He's paying $880 a day. Him and his wife didn't do any estate planning even. They held everything in joint tenancy. They thought it was a great idea. One of them passes away, the other one gets everything that's in their estate. But really what it did is it locked up their estate. So we have no ability to access the assets in the estate. So the husband, who's currently in this care, that's costing $880 a day, we simply ran the numbers and we realized, geez, if we don't do anything, in about 4 years, they'll go bankrupt.
Yeah.
And so you think, whoa, that's a big surprise. You know, so the point is you want to have the ability to access Medi-Cal in these situations, which is the California version of Medicaid, by the way. Not to be confused with Medicare. Medicare is, oftentimes people confuse these things. They think, well, I have Medicare, so I'm covered. But Medicare is just going to cover, you know, your medical needs, going to the hospital for a few days. It'll maybe will cover your first 20 days of skilled nursing care and a portion of the next 80 days. But usually these facilities will kick people out relatively quickly, okay? So you can't rely on Medicare. It's only there for a few months. So you have to ask yourself, what am I going to do in this situation? Well, a lot of people are asking that question and they're doing things about it because they're so worried that they will run out of funds. And then what are you going to do? So one of the tools that we use, other law attorneys use, are irrevocable asset protection trusts, where we take a portion, maybe a lot, depends on how comfortable you are. We put a portion of a person's estate in an irrevocable trust. So for state law purposes, it's not counted as part of your estate. But for tax law, federal purposes, it is. And we want that because we want to get step-up in basis on our capital assets. The only thing good about dying in the United States is all of our capital assets get a full step-up in tax basis. So what that means is the person who inherits that asset can sell it completely tax-free the very next day after the date of death. If you didn't hold it in a trust, incidentally, if you held it in joint tenancy, that doesn't happen. You only get half of the step-up in basis. Okay? So there are a lot of these concerns that overlap with estate planning and elder law. Okay? Let me stop here and ask, first of all, does anyone have any questions about what I've said so far?
So,
Yes.
irrevocable trust, you could not change it.
A revocable trust, excuse me?
Irrevocable trust, you could no longer change it.
An
Once it is registered.
An irrevocable trust is drafted very carefully so that you retain certain powers but give up other powers. So generally what you'll see, what might be typical in an irrevocable trust, is you give an asset such as a home to this irrevocable trust. Now in that trust you still have the ability to live in that home for the rest of your life, but you can't get the home back per se. You still have the ability, the trustee of that trust has the ability to sell that home and buy another home, or reinvest those proceeds, and then distribute out the proceeds from that trust to what we call a lifetime beneficiary. It's usually a child, okay? The lifetime beneficiary can then go ahead and pay for things that you need. We also have what's called a trust protector in this trust that has the ability to amend the trust, to hire and fire trustees if trustees are not doing what they're supposed to be doing. And probably the most important power that we have in this trust is the settlor, the person who sets it up, has the ability always to change the beneficiaries of this trust. So even though you can't get it back and put it in your own estate per se, you still have the ability to access it, and you still have the ability to say who gets what of it when you're gone. So in a circuitous manner, we still are able to control the irrevocable trust. But you're right, we can't just plain get it back. Okay? Does that make sense?
It is that, I'm going to ask, if what they call that mortgage, what they call it,
A reverse mortgage.
no, it's not reverse mortgage, because reverse mortgage is on a stake, on a real estate.
Yes.
And this you're talking about all the assets involved.
Well, it could be all, it could be a portion. Generally, we don't put all of them in there.
Okay.
Because, we have, first of all, we have checks coming in, Social Security, different things, we want to have accounts. If we're talking about a married couple, even under the Medi-Cal rules, we can generally have about $120,000 and still qualify for Medi-Cal. And for veterans benefits, the law was just changed so that they mimic the Medi-Cal rules. Which brings up an interesting point. You know, we're the only state in the United States that has not adopted the Deficit Reduction Act as far as Medicaid is concerned. What that means is that we, for the moment, can still do planning in California that cannot be done in any other state. The rules are very flexible for us, but that is going to change. Regulations have been written. We've been told that they're going to be implemented any day now. Once they're implemented, and a person, if they don't do advanced planning, they do what we call emergency planning, like the client that I was just talking about, they're already in skilled nursing care all of a sudden, then we can only save about half of the estate. If people plan in advance, then we can generally save 100% of it. But under the current rules, which are, again, more flexible, right now we can pretty much qualify anyone, okay? But again, as soon as that changes, that's gonna change. The VA also changed all the rules back in February. We don't know if they're going to go into effect. There's probably going to be a lot of lawsuits about them because the VA took a very harsh stance on getting aid and attendance benefits. And so for the moment, again, it's very easy to get those benefits, but that could change in the future. So the point of that is a lot of people right now are doing this planning thinking that they want to get in before the cutoff where the laws change. Okay? Yes?
I got a couple of questions. On the simple trust and an irrevocable, you're recommending simple. And the biggest difference between those two is?
Well, the simple trust versus the AB or ABC trust. I'm ignoring irrevocable trust. That's part of the elder law discussion. In the estate planning discussion, if we're just talking about who gets what upon death, how do they get it, who's in control, what I'm saying is that under most circumstances, not all, let's say if you're in a second marriage situation, you probably still want that AB trust, okay?
So will it say on the top of my trust simple or irrevocable?
No, but it'll definitely say in the distribution portion, at the death of the first spouse, this trust will either continue and nothing happens, that would be simple, or it'll say it's going to split apart into a bypass trust, an exemption trust, a credit shelter trust. There's lots of names for these things. And we're going to put half of the assets, we're going to put all the separate property of the spouse who passed away and half of the community property of the spouse that passed away. We're going to put that in that other trust. Okay, it'll say that if you have a more complicated trust. And in most circumstances, right now, under the law, the way it is, you probably want to switch it and just make it more simple, KISS theory, keep it simple, and, not have to pay all that administration cost later on.
Well, I just recently lost my spouse, but our trust was set up in the year 2000.
Mhm.
And they're telling me because I lost my spouse, I have to change my trust.
Well, what they're saying is you have to fund it. You have to change it into those sub-trusts that I'm talking about.
Okay.
So
I should tell them I want simple.
Unfortunately, after the date of death, there's nothing you can do. You have to separate it.
Okay.
So you're actually living through that experience right now of having to go through that huge hassle, that time and expense of administering the trust. Had it been, restated into a simple trust, then you would have basically had very little or nothing to do. Okay? Yes?
Yeah, can a trust stand alone without a will?
That's an interesting question. Yes, it can. A trust can stand alone without the will. However, you generally want the will because it's a safety net. Okay? It's gonna grab any assets that either you forgot to put in the trust or you intentionally kept out of the trust, and it's going to grab them in that safety net and it's going to pour it into the trust. That's why we call them pour over wills. As long as it's less than $150,000 that's out of the trust, it prevents a probate. The second it goes above $150,000, we're in a probate anyway. So we might as well have not even done the trust. We should have just done the will. So you want to have the trust and you want to have the pour over will as just a safety mechanism. You know, and there's lots of things that people don't think about. It could be a car, it could be jewelry, it could be forgotten about bonds or gold coins, and oh, this one account, I completely forgot about it, and boom, you're above that $150,000 mark. Yes?
So a will should be notarized?
No.
And registered in the city or what?
No. Actually, wills are witnessed in California, okay? Trust is notarized. And what you're bringing up is at the date of death, there is a legal requirement to lodge the will with the courthouse, the county courthouse where the person lived. But a trust is a completely, it's a document that no one has access to. So it's a secret document, so to speak. So you don't lodge it anywhere. Nobody gets to know what's in it. I mean, the family members get to
Until
know.
you die.
Well, you die. Your family members, your successor trustees. You know, generally we attorneys will create a different booklet, you know, of documents for your successors, so they know what to do, and also important, know what not to do as of the day of death. Okay, and so then they administer things. Okay.
Good.
Yes.
One more. Sorry.
No worries.
Could we not just make a will and then be notarized and registered it in the city?
Well, theoretically, someone could do a handwritten will. It's what we call a holographic will. Yeah, but you're forcing your heirs to go to court for a year or two and to prove to a judge. You know what a will is, technically? It's a set of instructions for a judge to read. That's what a will is. So a judge looks at it and says, okay, this is what she wanted. And somebody else over here in the background says, that's not what she wanted. So then the judge gets to say, okay, well, did she want that or didn't she want that? And that's how we get into will contests and problems, especially without the aid of an attorney. One of the things that people miss, which is very important, when you have an attorney who's drafting all the documents, besides the fact that it's done professionally, is that the attorney is an actual witness to your intent. So if somebody later on tries to say that this is not what you intended to do, the attorneys can be called into court and they say, no, I am not 100% certain. This is exactly what my client wanted to do. And that kind of shuts out all the people who would try to contest the terms of your estate plan.
Yeah, that's the problem as laymen. We could not understand the language of the attorneys.
Yeah, sometimes we like to speak in legalese, and you know, it's this constant battle that we have. Whether we can say something in plain English, but when we say something in plain English, we sort of think, it can be interpreted this way and that way, and we don't like that. We only like it to be interpreted in one possible way. So then we come up with all these shalls and, you know, may, or so that it makes the very technical and difficult to understand for the layman. But at least for a trained eye, it's very specific, and it can only go one way. Okay?
Yeah, that's what I mean. Could we not make a will, be notarized, and register it in the city?
Well, you don't notarize a will. You witness a will. Okay? And you don't register it anyway. Okay? So, well, we can talk about more of this later. Let's see. I think we have a couple more questions here.
It's simply
I own a home here with my girlfriend.
Yeah.
So we're both on the title and everything. What kind of document do I do, or do we do together, telling our kids that the first one dies, the other one gets to stay there until they're gone?
Yeah. You need to have a trust.
It's a trust.
You could either have a revocable trust or an irrevocable trust. Again, for the different reasons, whether we're talking about estate planning or elder law. But you need to have a trust, because again, if you just have it in joint tenancy, it can work to transfer it over to the other person, but you have several problems. One is you don't get that step up in tax basis, so the other person can't sell it tax-free. Another is, if you're caught in this situation where you need to get government benefits, the only thing that can be done is you have to go to a court under what's called a 3100 petition that you need. Okay? So, because if you have a revocable trust set up, you're using your own social security number, your own tax ID number. You never gave away the property. It's a see-through instrument. It is you. Okay? And because it's you, you can do whatever you want. And if you own it, it's counted as part of your countable assets as far as the government is concerned. If you have an irrevocable trust and you can't get those assets, pull them back 100%, then you do not own them from a government benefits perspective, and that allows you to access the government benefits. Okay? Yes?
What's a conservator?
A conservator. Well, a conservatorship, I think, is maybe one of the worst proceedings that anybody can go through. If you did not set up powers of attorney, okay, even sometimes even if you did set up powers of attorney, but they're not the right kind of powers of attorney, and someone needs to make decisions for you, either financially or for your health care, and they can't do it, you've got to go to probate court, again, prove to a judge that this is what the person would have wanted to do. What does the judge do? The judge assigns a different attorney to go investigate and see if this person is really in the shape that is claimed. Okay, that's additional funds and time. And sometimes you have the case where a person is, they don't necessarily want the conservatorship, so then they're fighting. Very expensive, very time-consuming process, completely unnecessary to the right powers of attorney in place. So a conservator and a conservatee, person who gets the conservatorship is the conservator, and the person who is conserved, they're the conservatee. Okay?
So is it not better to have a power of attorney than a conservator?
I always believe it's better to have a power of attorney. In fact, I think the power of attorney is maybe the most important document that you can have, the right kind of power of attorney. There's lots of different powers of attorney out there. People don't realize it. There's what we call dime store durable power of attorneys that people just buy, and they really just have like 1 or 2 pages. They don't allow you to do anything. And you have the estate planning powers of attorney that allow people to step in. It could be springing, or it could be effective now. Springing means it takes 2 doctors to say you're incapacitated in order for it to be effective. And then there's other law powers of attorney that basically allow everything underneath the sun and allow your loved ones to do the kind of planning that would be needed in order to obtain government benefits. Okay?
A power of attorney.
Yes.
Can you have 2 people having a power of attorney?
Only one person
Only one person?
has a power of attorney, and they can name more than one agent. Okay?
Okay.
They can name co-agents. I don't recommend it, but they could. Generally, it's best to have one agent, and if that agent can't serve, then you have another agent. If that agent can't serve, then you have a 3rd agent. If you don't have anyone to name, sometimes people will name private professional fiduciaries, or they'll name even a bank. Banks are more expensive, but they are very, very careful.
Can you name one of your family members?
That's usually the preferable way, you know.
This is what I mean.
Yeah.
To me, it's very important. I have 2 daughters.
Mhm.
And you name one of them and the other one. You know what I'm saying? How can
Yeah, that question comes up a lot. People have 2 kids, and they wonder, well, if I name just one of them, then the other one, their feelings are going to be hurt.
Yeah.
Whether they're an agent or a trustee.
Yeah.
You know what I say? I say the one who didn't get chosen, they're the lucky ones. The one who got chosen has so much work to do that it's a big job, first of all.
Oh.
Second of all, if you name them as co-agents or in your trust as co-trustees, the second that they disagree, they're in court fighting it out. It happens all the time. And that's worst case. The best case scenario is you always have to have 2 people signing off on everything. It's administratively difficult.
Now, you name as beneficiaries.
Mm-hmm. Beneficiaries of a retirement plan or life insurance?
No, or beneficiaries of your trusts. You
Uh-huh,
know what
okay.
I'm saying?
Okay.
You have this trust, and you have the two family members that you want to leave, for them to add that.
Yeah.
I mean, share alike. What I'm saying is,
You're saying split it equally between the 2 kids?
yes.
Yeah.
And it's equally.
Yeah.
And it's one, the 2 of them have to agree. If not, something happens.
Oh, you're saying if there's a specific like personal property item, such as a piece of artwork or something? Yeah, so there's ways to handle that. The things can be valued. There's usually what's called a non-pro rata distribution clause in the trust that says whoever serving as trustee can allocate the asset to one person, and its equal fair market value in cash dollars get allocated to the other person. Okay? So there's ways of dealing with that. Also, if you want specific items to go to specific people, usually it's best if people will create a memorandum and actually write out who they want to get what.
Okay.
I always say don't tell them, because I always tell my clients not to tell the beneficiaries that they're going to get this, because so many times I've had this situation where, let's say, a grandmother, 30, 40 years ago, told one daughter that she was going to get, for instance, the engagement ring when she passed away. And the other child then has a daughter, so a granddaughter. You know, all these years go by, and grandmother tells the granddaughter, "Oh, I want you to have my engagement ring when I pass away." And they get in a full-blown fight over the engagement ring. And it's true. She said it to both people. So really, the best thing is just to write it down. And when you change your mind, just rip it up and write it down again. And let them know where it's at.
Or give it to them as you are alive. And
Or
just
do it
get
during
rid
life.
of it.
Yeah, you could do it during life.
I
Exactly.
think it's the best thing is to just go ahead. This is yours and this is yours.
I wish you were my mother.
It's right. I get that.
Yeah.
All of mine, but I don't wear anything. This is yours. If you like it or not, I give it to you. And
Yeah.
this is for you. If you like it or not, it's yours.
Life is not fair. You're right. You're right.
And those little things that later on brings a lot of
Yeah.
difficulties.
It's interesting because fights over money almost always start from the very littlest of things. Yes.
I have a question when having my will in front of one garden for the 5 years. I have a meeting many times when my son died at the Medicaid, when my daughter had a disability, the other one. Or another set of years that the lawyer advised me that I have 2 daughters. And I put one that I know that she can handle these things, the other is disabled. But if somebody claims what I already have specified that I want to use for them, then said necessary. So we want that next program to be necessary.
Well, you raise a completely different issue, very, very important issue, which is what's known as a special needs trust. Do you have a special needs trust?
Well, I didn't have my that's on my own.
Okay, so you don't have a child with special needs currently?
No, now.
Okay.
Well, I have this daughter now, but I don't know if I can change now.
Because you said she's on disability.
She's
Is she on SSI or SSDI? Do you know?
SSI.
SSI.
She never worked, never went to divorce.
So you really need a special needs trust for her, because if she gets anything, she has more than $2,000, then they're going to kick her off of SSI.
Well, the thing is that what I own in behalf of one mother has another, and that's my father, question with his stable daughter.
So if certain things are exempt, like a house, you know, a house can be given to somebody with special needs, and it reduces part of what they can get, but it doesn't necessarily preclude 100%. But this kind of stuff, you really want to be careful. You really want to look at it and analyze it and make sure, because those government benefits can add up to hundreds of thousands, if not millions of dollars over the course of a lifetime. And if you mess it up, what you have to do, what they have to do rather, later, is they have to go to court under what's called a D4A provision. Get a D4A special needs trust. Very expensive, always got to go back to court, got to report it, and ultimately when they're gone, all that money needs to be paid back to the state.
That's what I have for my son.
Yeah.
He's very expensive, will, but he died. So
Yeah.
instead of this part, I changed to the lawyer and advice. Maybe for my 2 granddaughters. But now because my daughter is disabled, I think that the need is from her more than from my grandmother.
Yeah, well, certainly whenever.
And we did that. I did about a year ago and made it for that.
Yeah, you bring up a good point. When you have a special needs beneficiary, their needs are always far greater than that of the other beneficiaries. So,
We have to have her to be that
You really got to analyze it and look at the assets and the situation and figure out what makes sense to do. You know, and that brings us also to the point that when you want to reanalyze your documents, well, it's anytime there's a change in the law, anytime there's a change in life circumstances, you know, or you just plain change your mind about something, you want to take a look at this stuff and probably redo it. Okay? So, yes,
It's
ma'am.
special lawyer that specializes in the disability case. I did have one in Europe for years. But now I don't feel like driving that far. Every time I have
Yeah.
to change drawing a street according to somebody here.
Well, you can call my office and I'm happy to look at it. We do that complimentary, so we can let you know whether it needs to be changed or not. Okay? Yes, ma'am.
We have a house. When we bought it, we put our daughter, my husband and I, and my daughter on the title. Now, my husband got the stroke, and he probably needs to go somewhere. I don't know, because I cannot take care of him because I have a cancer, and it's too much for me. Now, in this case, probably we have to sell the house. I don't know, I need your idea, to sell the house and go to assisted living.
Okay,
But this
so,
one, the question is, what about if the money's gone, because we have a mortgage, and we have to pay that one before, and we'll be probably 5-6 years with the money for the house. What happened after that? Will it make it there only?
yeah, you bring up the classic situation of what you don't want to have happen. First of all, you have the joint tenancy, and a lot of people don't realize when they put their child on as a joint tenant, you've literally given away that 1/3 of that asset, in this case, to that child. So for starters, let's say, God forbid, the child runs over a 35-year-old plastic surgeon and gets sued for $10 million, they can come and attach your house, okay? So you open yourself up to liability when you have that joint tenancy, okay? Second thing, if you have the ability to set up an irrevocable trust and move that house into the irrevocable trust, it becomes 100% asset protected.
I have revocable.
Right, you have a revocable trust, right, which probably is not going to help you. If I could see your powers of attorney, I could tell you what you may or may not be able to do. And hopefully, you have good enough powers of attorney that will allow you to maneuver things in a way to get rid of that revocable trust and instead set up a plan, an irrevocable trust plan, that, by the way, does everything that the revocable trust plan does too. It avoids probate, avoids a conservatorship, gets you all the tax benefits, says who gets what, all of these things. But at the same time, it will enable him to qualify for things like Medi-Cal, you know?
We're not qualified for that.
Not currently. Maybe he doesn't need it currently. But in the future, if he needs it, he'll be able to qualify. Okay? Also, if you just leave it in your names, and let's say somebody does qualify for Medi-Cal, because sometimes you actually can qualify because you have just exempt assets. Well, what happens is when the husband and wife pass away, the state comes back and they put a lien against the house to get paid back all that money that was paid, so it could essentially bankrupt the estate. It gets really complicated, but you definitely want to do different kind of plans. I see you standing over there. I think my time is up.
Just one or two more questions. One or two more questions. Yeah.
Yes, sir.
I just want to know how much is the cost to put a living trust?
A living trust for a couple, it tends to be about $2,000 or $3,000 to do the living trust, the pour-over wills, powers of attorney for healthcare, powers of attorney for finances, HIPAA authorizations, fund the trust with the house, record a deed, do a preliminary change in ownership report so property taxes don't go up, pay the recording fees, do an assignment, the whole package, you know. But it depends. I mean, if somebody has 10 properties, then things get more complicated. Or if you want to
So
put
you
in,
put a percentage of the asset?
you know, when you're talking about a regular revocable trust, you pretty much want to put all of your assets in a regular revocable trust. There's
So what I mean, your cost is a percentage of the asset?
No. Our cost is based on the hours it takes to put things together. So we actually have a price sheet, and it's just based on whatever it is that a client wants to do, once we've explained to them the different options, and they decide. They say, well, let's just keep it simple, let's do this. Some people say, no, I want this protection, and I want to be able to do this, but these other things can cost more money because maybe it takes, 5 more hours to set it up. See? Yes. I think you're right.
What's the cost just to renew your trust?
We do that complimentary at my office. Yeah.
What if you got no asset, it's only your SS benefit? What will happen to you when you get sick?
If you have no
You
assets,
cannot take care of yourself.
if you have no assets then, and you need skilled nursing or something like this, the government will come in and take care of you, so you don't even have to worry about this. A lot of times, by the way, I get people that they talk to a social worker or somebody who, when somebody needs skilled nursing, and whether it's mom, dad, husband, wife, and they say, no problem, just, spend all your money and then come back in 5 years when all your money's gone and they'll apply and they'll qualify for Medi-Cal. And then they come and they sit down with me and they say, okay, so we listened to the social worker, they said just go ahead and spend it, and then they qualify it, and they say, what do we need to do now? I say, nothing, just apply. I wish you came and saw me 5 years ago. I could have saved $500,000 or whatever the amount of money is.
You made a straight account that we will not have to pay taxes when we give the money away, but our beneficiaries will.
No, not estate taxes. If there's income taxes owed on that asset, yes, but
Well, how
not
do
estate
you
taxes.
determine that?
It depends on how much you bought the asset for, okay? Depends on whether you got to step up in tax
What if
basis.
it's only cash?
It's only cash, no taxes.
So the kids will not have to pay any?
No.
No. Even if you have $1 million in the bank?
Even if you have $10 million in the bank,
Wow.
if you're a married couple, $5 million for something.
5 million?
Yeah.